Next is an information item. Utah Open and Public Meeting Act. AAG Michelle Buse, you have a presentation for us. We welcome you to this part of the meeting.
Just trying to unmute myself. There we go. I know that you're tired and it's been a long day for you, and I will do my best not to take 45 minutes. And you can just pretend that I'm telling you your bedtime story. That once upon a time, there were a group of legislators that really, really felt it was important that all of the work that you do as a board, this is not clicking forward for me, there we go, that all of the work that you do as a board be done in public, that boards exist to aid in the conduct of the people's business and should therefore conduct their deliberations and take their actions openly. It's not very often that our laws have an intent of the law put right in the statute with it. But this is one where we don't have to go back and research what was it that they were thinking when they made this law. They made sure that there is the intent of the law is in the law itself. That a meeting, including a workshop or an executive session in which a quorum is present, must be open to the public unless there is a legal exception that exists. In order for us to understand when the Open Meetings Act applies to the actions that you take as a board, we need to make sure that we understand some basic definitions that exist in the law. And those definitions include the definition of what is a public body. And so they define a public body in the law as an administrative, advisory, executive, or legislative body. And you act in a legislative capacity by making those board rules that all of our schools and our teachers follow. So you do work in that capacity. That you as a public body were put together or established by a statute, a rule, an ordinance, or a resolution, which you are. That you are a public body when you have 2 or more people there, and that you spend or supported by public funds, and that you make decisions about the public's business. So a public body has to fit all of these different things in order for the Open and Public Meetings Act to apply. Since you do fit all of those things, whenever you have a quorum, oh dear, I just unscreen shared. Whenever you have a quorum that's present, I'm going to keep talking, even though it's going to take me a second to open that back up. Whenever you have a quorum that's present, you have those obligations to meet in the Open and Public Meetings Act. Give me just one second and I will screen share that again. Oh, what a night to have technical difficulties. I'm sorry. Flip through it. Not every time you get together counts as a meeting under the Open and Public Meetings Act, but any time that you have a quorum of you as a group together or meeting together, that you can be convening in person or through electronic communications, which we're going to talk about and ask you a couple of questions to think about in just a minute, and that you are addressing the board's business. So there are some times that you will get together as a board that it does not qualify as a meeting. And those kinds of things that are not a meeting, that you don't have to follow the Open and Public Meetings Act, include times when you have a social gathering or a chance meeting that some of you would end up in the same location at the same time or conversing over the same things. Another instance, which is unusual and doesn't happen real often, is when in that meeting you are not expending any public funds and it is purely for the implementation of administrative or operational matters. That would be an example of your board orientation when you as board members come together, and it's simply letting you know what your benefits are, letting you know how things operate, and it's not a time when you're going to be taking formal public action. For those times when you do meet all of those criteria and you have to comply with the Open and Public Meetings Act, this is the process that your staff does to make sure that you're in compliance with it. The law requires that whenever you're going to be meeting to decide the public's business, that you have to make the public aware of it, that you have to do that by giving them the date and the time when you'll be meeting, the location that you'll be meeting at, and an agenda of the meeting. And your agenda has to list every item that you're going to take action on, and it has to list it with reasonable specificity so that an individual who is reading it would be made aware of what sort of things you're going to be talking about. So that's why our Lorraine is so good at making sure that we have everything there on time, because that all has to be done for the public at least 24 hours before the meeting takes place. You as a board can actually begin a meeting without a quorum being present if you're waiting for someone, but you cannot take official action until you have a quorum present at the meeting. You also, as a board, cannot take any action on any item that was not listed on the agenda. And so that's why we try so carefully to follow what the agenda has. As a public body, each public body is required to establish rules of order. We use a modified version of Robert's Rules of Order. You do have the authority through your bylaws that you set to be able to give yourself an exception to any of those Robert's Rules of Orders if you officially adopt that in your bylaws. Additionally, every public body is subject to the act. I already said that. You have to establish your own rules. The next section is what we just came out of, and that is closed meetings. And what are the times that you can have a closed meeting? A closed meeting must always start with an open meeting. So even if the only thing that we have to really accomplish in that meeting is something that will be happening in a closed meeting, we must start with an open meeting. We must have a quorum present, and we must have a vote with at least 2/3 of the members who are present vote allowed to close the meeting. We have to have a record of each vote that's taken, not just as a group. And that's why board chair or whoever vice chair that's sitting will always ask you to give a vocal vote. We have to have a record of each vote that's taken. The reasons that you can go into a closed meeting or closed session are listed in the law, and they are to discuss personnel matters, contract negotiations, or property negotiations, for things that are reasonably imminent litigation. And we need to know that litigation, our courts have said, include things that are administrative litigation that happens. Also, you can go into closed session to discuss security matters. We've tried to keep up by looking at how the court interprets this law. And you're going to have an instance that will come up in the near future, most likely, where you act as a hearing body. And the Supreme Court of Utah has said that in an action where you act as a hearing body or a hearing panel in a quasi-judicial action, so where you're a hearing body, it says that as long as you collect all of your information in public and you announce your end decision in public, that you may go into a closed session or dismiss your open session and deliberate in private. So that is an unusual circumstance that may come forward that I don't want you to be overly concerned about, to know that that is an exception to it as well. I wanted to spend just a minute to discuss with you, in the law, it talks about the difference between an open meeting and a public forum, that you are entitled to be able to have order in your meetings. Your meetings are not a public forum. They're actually considered to be a limited public forum. And because of that, individuals are welcome to attend the open portion of a meeting, but they don't always have the right to speak or interrupt the proceedings or have an opportunity to speak to every single thing that you do as a public body. It would be difficult for you to complete the business that you have at hand if that were the case. In fact, you were selected by the members of the public who elected you to conduct the business of the public schools on their behalf. And so therefore, you do provide an opportunity at most of your meetings for public comment, that individuals can comment on anything that's on the agenda. And they can comment on things even outside of the agenda. But after that, the public is entitled to observe, but you're the ones conducting the business. And in fact, if observers disrupt your ability to be able to conduct business, they may be forced to leave or asked to leave the meeting so that you're able to do the things that you need to do. In terms of keeping a record of the meeting, each one of your meetings is recorded under state law. That's a requirement. The recordings are kept, but the official record of the meeting is not the recording. The official record of the meeting is what Lorraine is keeping. It's the written minutes and it's what you adopt. Something that you need to be aware of is that there are very specific things that have to be in the minutes. And the things that have to be in those minutes include the date, time, and place, and the actions taken and vote. Sometimes a board member will be upset because their comment that they made wasn't in the minutes. But board member comments are not a part of the minutes and are generally not taken down as minutes. There's just the action that's taken and the vote that results from the action that you take. It is actually discretionary as to whether to include comments of board members. And you can imagine if Ms. Lorraine were required to be able to write or required to have to write down every comment made by every board member, how lengthy those board minutes would be.
A point of order, Chair.
Oh,
Someone has stated we're not streaming. Can we double check that? Sorry, Michelle.
okay, I'm going to go ahead and continue. The minutes do, however, have to have a list of all the individuals who are not members of the public body who are allowed to come and be recognized by the chair. And so Lorraine does make a summary or a substance of the comments that we had from public comment. Closed meetings are recorded in their entirety except for personnel or security issues, and minutes are taken out of closed meetings as well. If there's a violation of the Open and Public Meetings Act, an individual person can file a suit in district court, and the remedy, if a judge finds that the public body did violate the law, the remedy is that the actions that were taken during that period of violation are void. And so you as a public body would have to rehear and redeliberate those actions. And you did that today. You solved that problem when someone, not that a judge told you, but you made that decision to accommodate the individual who had concerns and do that already. I know that it's late. I took the opportunity to kind of give you a couple of think about this. Just think in your mind, if this situation happened, would this be a violation of the Open and Public Meetings Law? This is a board in another state that was having ongoing discussions among the members of the board outside of board meeting about the superintendent and the superintendent's ability to complete the contract and whether or not they wanted to keep the superintendent in place. And so as the board members contacted one another, it included one-on-one personal contacts that board members had with one another. They also made telephone calls to one another. And when the time came for them to actually take action in the public meeting, they did determine to terminate the contract of the superintendent. And the superintendent filed a lawsuit claiming that the individual board members had spent so much time conversing with one another, they had made the decision before they actually came into the meeting. I just want you to think about that for a second and think, okay, if that were you and you were the judge, would you say that that board had actually violated the law, or was what they did appropriate under the Open and Public Meetings Act? The court in this case said that what had happened was actually a series of unofficial closed meetings with less than a quorum, but totaling a quorum together. When totaling together, it ended up being a quorum. So the judge actually looked at how many board members talked to other board members, whether their conversations were about something that they were going to make a decision of in the open meeting. So did they conduct their deliberations with one another and make that decision prior to meeting? A meeting can be conducted in person or through electronic communications, the court said. That technically there may have been no quorum, but the courts are not so naive as to be blind to the fact that those inclined to violate the open meetings law could do so using the quorum requirement as a shield. This would violate the spirit of the open meetings law and would render an unreasonable result that was not intended by our legislature. So when you make those conversations and decisions outside of the closed meeting even, it can still be a violation. I'm going to skip that and just talk to you just for a second about electronic communications that involve a quorum. So if you send a text message or an email to a group of individuals that are your fellow board members, that's okay. We saw, for example, board member Earl may have sent some information to us a couple of meetings ago and asked board members to review that information prior. If there was no conversation that happened after it, and it was simply presenting information to you, that's okay. If the superintendent or staff members send you information through the board's attachments or send information to you in preparation for a board meeting, as long as there isn't deliberation that happens prior to the board meeting, simply providing you with information, the courts have said is okay and is not a violation of the Open and Public Meetings Act. So I don't want you to be concerned that you can never discuss things. The other thing is you can discuss with not a quorum. So if you need to bounce something off another board member and you need to call them and say, you know, I'm thinking about making a motion like this. How do you think, or do you have some input to help me write that motion? Or would you be in support of that motion? It's okay for less than a quorum of board members to discuss an item outside of the board meeting. So I don't want you to feel like you can't even be cooperative with one another. You can. It's that the deliberation can't include more than a quorum of board members if it's something that you're going to be voting on at a board meeting. So I'm just going to summarize it with a couple of things that you ask yourself when you're having communications with other members of the board, that you want to play it safe, stay on the safe side of this law. Things like, are we communicating about official business? If we are, how many people are we communicating with? Have we hit that quorum number? Will we be taking a vote on this matter? If it's an issue that you're not going to be voting on, then it doesn't even count. It's not one of those things that's covered by the Open and Public Meetings Act. Remember, it's deliberations of the public's business that you're going to be making decisions on. How many board members are involved in the communication? So if your text message or you're bouncing the idea off, it's less than a quorum of members, it's not a violation of the Open and Public Meetings Act. Is there any evidence of trying to circumvent the spirit of the law? Are you trying to go to each one, have that conversation, and try and avoid having to have that conversation in public, when really we think about what the intent of the law is to have you have your deliberations of those issues that are open meeting issues in the open, and those that are closed meeting issues in an appropriate closed meeting. So be on the safe side. It's most likely a meeting and violates the law if at any point in time you have a majority of board members participate in something that would equate to a conference call, something that you're deliberating back and forth on. The court cases that I've read say that can be through email rather than a conference call if you deliberate back and forth, back and forth. They call them serial meetings. Serial meetings, each consisting of less than a quorum, if you really are deliberating rather than just sharing information with your fellow board members. A majority of board members using email or text messages to discuss, express approval, or express disapproval of a matter that is before the board or is likely to come before the board. It's most likely going to violate the law. So save those discussions for when you're together as a board in that open meeting. There's a couple of things that I wanted to ask you is to treat electronic communications that involve back and forth exchange of information the same as a conference call. So if it's a text message, think, do I have more than a quorum being involved? If it's an email, do I have more than a quorum being involved? If I do, then I probably shouldn't discuss any issues that are going to be on our agenda. I need to move my little picture here. Avoid the use of a reply all, copy, or forward to other board members, because that gets that conversation going back and forth. I thought I would throw in a little, I want to call it just an advice on reply all, copy or forward. Every single one of you as board members have your plate full with the constituents that you have, that you're caring for, that you're representing. And so you've kind of had that experience in this last week of somebody saying, send an email to every single board member about this. And perhaps you've seen that this last week, that might not be the most efficient way to even have other individuals communicate with board members, because it's so overwhelming and so time consuming that those messages become not as valued because there are so many of them. So instead, if you want to have board members be informed, you might want to invite them to send a message to their own representative board member, so that the board member who is looking at it sees them as their constituents, and it feels like there is more of a reason for them to take the time to go through all of those emails, and maybe would make it a little more efficient use of board members' times than doing blanket emails to every single board member. So not just when you're communicating with each other, I'd ask you to be cautious of each other's time and the burden that you're giving to your own constituents, and make sure that you kind of focus those requests when you ask the public to communicate with board members. Emails from board leadership to all members that don't require a response are never something that's going to violate the Open and Public Meetings Act, because you're not deliberating. It's simply information being provided to you, and the courts have been very clear that when it's simply information being provided to you, it doesn't violate the Open and Public Meetings Act. That is it. So I tried to do super fast because you're already way behind, and I know you're tired. It's been a long day, but I hope that that kind of gives you a little bit of an overview of the Open and Public Meetings Act, and know that Brian and I are here to answer your questions that you have on specific things. If not tonight, when they come up, please feel free to call us. You have our phone numbers on the list. You have our emails. We're here for you. You are our client, and we're here to make sure that you have the support that you need. So that's all. Thank you.
We do have a couple hands raised, but AG Buse, can you speak to emails that are coming from you or Brian?
Yes, thank you for bringing that up. Any
Sure.
emails that you receive from Brian or myself are actually protected. They're private emails. They're things that should only be used by you as a board member individually, and as a board, as a group. They're not things that should be shared outside of that, because they're protected by the attorney-client privilege. You are our client as the board. And so we would ask that whenever Brian or I communicate with you, that you treat that as an attorney-client privileged communication, and that those are kept between you and us as your attorneys. And then when you as a board, as a group, make a decision that you want something that we say, an opinion or a decision to be released, you can do that as a board, as a group. But you as an individual board member don't have the right to waive that attorney-client privilege yourself. So if we send something out to the board, it's information for you as a board. You are expected as an individual board member to protect that under attorney-client privilege, unless as a board group, you have made the decision to waive that.
Okay, thank you. We have a few hands raised. Member Earl.
Yes, thank you. You've always been really good about responding to questions and things that we've had, so I do appreciate that. My question has to do with maybe like an event type of a situation. So for example, like early childhood, sometimes like I attended a movie and I was invited by, I think, if I remember right, it was staff. It might have even been outside staff, but there were a number of people in attendance there. That type of a thing, once again, would not be considered an issue, even if we spoke there about early childhood or whatever. The intent is not to make a motion at that point. Or do you know what I mean? It's not about the board's business. We're attending an informational thing. Would that be accurate? What's the stipulation there?
I agree with you. We try to be overly cautious if we know that there's going to be an event that more than a quorum of you as board members are going to be at. we'll discuss whether that should be publicized, because we do try to be overly protective of you. But if you are invited to an event and you come and just by chance there happens to be more than a quorum, you can do one of two things. If there's not something that you're going to be taking any action on at all, it's simply a social gathering, it's not counted and you can stay there. If you feel uncomfortable because in your mind you think that there may be an opportunity coming up in the near future, in the identified future, that you're going to take an action about the event that you're at, then maybe one of you might want to say, I'll be the one who leaves so that we don't have a quorum here. Because it could happen that it be something, let's say early childhood, and you are actually making decisions about it. You're making grant decisions or you're making decisions about it in the future, then you would want to have one of you leave.
Okay, I see. That's what I wanted. Okay, so just more on a precautionary kind of a thing. Okay,
Absolutely.
Thank you.
Thank you. Board Member Cannon.
Thank you. Michelle, I have a question about the closed session minutes. So
Yes.
You told us that we go into closed session and minutes are taken. However, no votes are allowed to be taken in closed session. And you said whether or not board member comments are recorded is sort of a vague area. So I am wondering what is contained in those closed session minutes, and also after the fact, who and when could those closed session minutes be accessed?
They're actually records that are protected, and so it's very unlikely that they would be able to be accessed. It would have to be done through a court action, and so a judge would be involved in that, and most likely the judge would review them by himself or herself in camera to determine whether or not it would violate someone's privacy or violate the law to disclose those. But it's just a summary of what has happened. And so it would not have votes because no votes are taken in closed session. It would just be a summary of what the discussion is.
And AAG Buse, can you speak to, there are parts of the executive session that are recorded and required to be recorded. Can you speak to that?
Yes, when we talk to you about litigation items, negotiation for property and contracts, those are actually still recorded. And so there's a complete recording of those. The items that there is not a recording of is when you discuss personnel issues, those are not recorded. And all there is simply the generalized minutes about it.
Thank you. Board Member Lear.
Back to your comment about one board member revealing or sharing information from an AG. What's the penalty for that?
The penalty for that, there's no individual personal penalty for someone violating that. It would be more an issue of that it puts the board at risk because it discloses information that the board wasn't ready to have disclosed at that point in time. So you would have to decide as a board whether you were going to take any action against a board member who did that.
Like maybe impeachment?
The board can't impeach its own members. So we kind of gave
right.
that lowdown this week that boards are not entitled to impeach their own members, but they can take board members off of committee assignments or different assignments that the board leadership has given to them.
Thanks.
So that's something that would be taken away from them.
Yeah, thank you.
Okay. Thank you. My screen looks a little different now, so I'm scanning this little box. Thank you, AAG Buse. I know you and Brian are a text, email, phone call away, and we appreciate all that you do for it. Definitely appreciate this briefing today, and it just seems like the magic number that needs to be in our heads is the magic number is 8. It's always 8.
Yes.
If we've got 8 or more, we need to know what we're doing. If there's and it takes 8 to do something really good, and it takes 8 members to maybe do something that's not so good. So 8's the magic number, and then occasionally there'll be something that goes out to board members as an FYI, and it's quick to respond and say, oh, thank you, and or here's some other comment, and some things might get added into that. And occasionally if that happens, then I kind of have a reputation of just weighing in and reminding everybody that this is to stay a FYI and not be a email or text or email conversation. So we can help each other stay in a very safe place by being smart with what we've learned in this briefing. So thank you.
Thank you, sir.